welcome to this episode of Out of Curiosity. And with us today is Ken Rashbaum with Barton LLP. Hi, Ken. How you doing today?
Great. Good to see you.
So, Ken, I'm really happy that you're able to join us. I've been tracking you and your career for the last 15 years or so. I mean, you've had really a pretty extensive experience. I mean, you were part of the you were an assistant district attorney, back in the late 70s and 80s, and you've been a partner at Sedgwick. You've even worked for a provider, and most recently, you've been a partner at Barton LLP. So you have a lot of experience. Could you tell me a little bit about your practice, and then we can talk a little bit about your journey?
Yeah, sure. I had the Privacy, Cybersecurity, and Technology Transactions Group at Barton LLP. We're a full-service business law firm. About a third of our client base is from outside the U.S. And as you can imagine, with global e-commerce proliferating the way it has been, there has been a tremendous amount of interest and need for legal work with regard to regulations on moving data from place to place, storing it, processing it, sharing it, collecting it across national borders and across even state borders. So what I do falls into a number of different buckets. Some of it is traditional technology work with regard to data breach counsel. Somebody has a cyber attack that results in a loss of protected data. They call me, and I will quarterback the initiative, bringing in forensic investigators, determining what state and entities need to be notified and when, what individuals need to be notified and when. Many times I will conclude nobody needs to be notified once you do the investigation. So a large part of that aspect of the practice is what I call talking people in off the ledge, making sure that they don't make a notification. They can't walk back later because they didn't legally, or for a business reason, have to do that. Another aspect of what I do is transactional. I will draft, review, and negotiate license agreements for software. A lot of our clients are software developers. Sometimes I'm on the other side of that, preparing and negotiating the contract on behalf of the customer. That also leads into some of the work that I do for private equity, venture capital, and mergers and acquisitions, where an increasing amount of due diligence is regulatory compliance. Nobody wants to buy a risk. Nobody wants to invest in a risk. So I'll be part of the data review team that will be looking at contracts, insurance policies, procedures, training materials, employee handbooks to determine levels of compliance with the laws and regulations that apply in that particular space. Lastly, I have over 25 years experience as a litigator. In addition to criminal in the district attorney's office, I have done a great deal of civil trial work in federal and state courts, argued in the Second Circuit Court of Appeals, as well as the appellate division of the state of New York. And I've tried dozens and dozens of cases, many of them to verdict. And these days, litigation skills come in handy in a couple of ways. One is when we're dealing with employment-related matters, particularly trade secret violations or similar, where employees take data they're not entitled to take to their own new companies or to other competing companies. And the other aspect of the litigation, of course, is EDiscovery. And EDiscovery has changed dramatically in the years that I've been involved in it. And while litigation has been somewhat on hold because of the lockdowns in the courts, now we are seeing that the courts are starting to open up, and the judges want everything done yesterday in terms of discovery, or the way I put it to some of my clients, the old rocket dockets are now warp speed dockets. And you're going to have a very hard time convincing a federal judge that you need more time when he or she has an administrative judge looking over his or her shoulder, asking why this old case has been around for so long.
Right.
So
So,
that's kind of a thumbnail of what I do.
it sounds like, just to kind of summarize, you have a lot of experience ranging from the litigation side to the cyber, and you've been, it sounds like even like you're kind of a contract wonk a little bit too. So, and that ties all nicely to the kind of the e-discovery information governance piece. And I like that you brought up kind of the cross-border thing, because I've always, in our conversations, I've always viewed you as one of the kind of the top thought leaders around cross-border challenges. And in fact, I think that's how I met you at first. I think was at the first Sedona Working Group 6 meeting that they had, a very long time ago in Spain. And I remember at that time I was still struggling, but with try to as someone who was doing data collections and computer forensics, gathering and collecting data, creating model contracts so we can preserve and collect and deal with the data here for U.S. litigation. So can you maybe share with me a little bit of how things have changed and over the last few years when it comes to cross-border? What are the things that you're seeing from a trend perspective and data, at least from the processing side of delivering it for U.S. litigation?
Well, there are new requirements and new scrutiny in Europe over what U.S. entities do, taking data from Europe and that's created by European Union residents and moving it to the United States for use in litigation, which presses many buttons for Europeans, not the least of which is that if any of it ever goes to trial or is used as an exhibit in a motion, it's public. And the general principle in Europe is you can't send personal data outside the European Economic Area without consent of the data subject or for a reason that's enumerated in the General Data Protection Regulation, the GDPR. And for a while, it was thought, well, gee, there are jurisdictions that really serious about this, like France and Italy and Germany and Switzerland, and some that were less so, like Ireland and the UK. And the Netherlands kind of fell somewhere in between that, as did Belgium. Now, all of a sudden, there's a lot more attention to this. Germany, in particular, which has been strict for a very long time, is cracking down even more, particularly in the wake of the case last summer called Schrems 2, that invalidated the Privacy Shield framework. One of the reasons it was invalidated was because of the lack of control over how data is distributed in the United States, and the lack of really a remedy for aggrieved European citizens. So the whole concept of data transfers to the United States is now somewhat fraught with peril. And any e-discovery company, any law firm that's working with an e-discovery company has to answer to two masters. One, of course, is the judge in the case, particularly if it's a federal judge. And the second is the European company. You have to have your ducks in a row, particularly in Germany and France, and increasingly in Ireland now, before you're going to even be allowed to collect the data, let alone transfer it here.
Yeah, it is complex. So, what are you advising to your e-discovery, clients who invested into the Data Privacy Shield and marketed heavily on their website and said we were good, right? We know how to manage EU data. What are they doing now, and how are they protecting themselves?
Well, there's no discretion here. The Privacy Shield framework is gone. You can't use it. There is some talk in the U.S. Well, you can still use it anyway, but my response is good luck with that. The Europeans are not going to like that. You're flying in the face of their highest court. You're not showing respect for their legal system. Don't expect much if that's the road you want to travel on. The European Commission recently published new standard contractual clauses for use with data protection addenda, and they are to be used starting right now. So that's an accepted data transfer mechanism, as long as the parties can adhere to the controls in those clauses. One thing that's nice is they broke it down this time into modules. So you have a controller to processor module, and you have a processor to processor module. You know, if you processor to processor is otherwise known as sub-processors. The EDiscovery company using a review company in India, for example, or even in South Carolina or somewhere else in the United States, for that matter. There's a module for that. There are standards for that. They're not radically different than were in the old clauses, but they're different enough that you need to know about them. And I've been working with a client over the last 2 weeks, answering their questions over what's different, what they have to do, interpreting some of the clauses, because sometimes it's not exactly written in the clearest English, just from what it means from a business point of view. So anybody who is using Privacy Shield has got to now find something new, either the standard contractual clauses or binding corporate rules, which are global rules of conduct for the entire organization. Problem with binding corporate rules is they have to be approved by the supervisory authority of each member state in Europe, and that takes a very long time.
Yeah, I mean, if I remember correctly, corporate binding rules were really based around, dealing with internal data like HR data. That's kind of the original intent around them, right?
Well, it's more than that. That was a large part of it, definitely. But it's also any other any other personal data that may have to be transferred, generally within the company, from facilities in one country to another. So your point, although you didn't say it, but I think a good point here is that it's not good for everything.
Yeah, it's not a panacea, as they say, right? So help me understand a little bit of how you went from an ADA to starting to focus on this career in e-discovery and cyber, and really developing this expertise. What were the lines that that drew you to that area?
Well, it's great that you asked that. It's an interesting journey, and I didn't mention this before, but I teach 2 courses at Fordham Law School in privacy and cybersecurity, and I tell them my path in the first class, just to let them know that it's not linear, and that you don't have to have a computer science degree in order to be in this space. That's helpful. Whenever I have a student who has such a degree, he or she becomes my go-to technical resource for the semester. But the nuances of how the law approaches this and the business aspects sometimes are a bit lost on them. So the class takes on kind of a holistic approach where everybody learns from everybody else, and it's a seminar. So that's the way I like to do it. But the way I got involved in this space was through healthcare. When I left the DA's office, I had gone to a firm that doesn't exist anymore. It's called Bauer and Gardner, where I was doing medical malpractice defense and product liability. When I left there and went to Sedgwick, I was doing a lot more product liability, a lot less medical. But in the medical space, I started increasingly being asked to do grand rounds and in-service lectures, both of which are teaching rounds at medical schools and hospitals with medical school affiliations on data privacy issues. That in turn led me to develop a practice in HIPAA. And I was one of the first HIPAA counsel in the New York area back in the early 2000s. We had a team of 8 lawyers in New York, plus several more in offices in Los Angeles and Chicago, where we were doing the HIPAA compliance for hospitals and hospital systems and health insurers, because HIPAA was brand new at that time. So one of the aspects of HIPAA that was critical was electronic medical records. It was a gleam in people's eyes back then. HIPAA has 2 rules, right? The privacy rule and the security rule. So the security rule was written for electronic medical records, which really didn't even exist back then.
Hmm.
It was a big deal. So, it existed for things like pathology reports and maybe some radiology reports. That was really about it. But the drafters knew this was coming. They were very, very prescient. So I had to really get up to speed quickly on privacy issues around distribution of electronic information, security issues, management of it. We had to design training materials for it with my group, working with the IT groups of these hospitals. And so we were doing that. And then one day, and then I got into the international space because the firm chairman was visiting from San Francisco at Sedgwick. And he said to me, Ken, we have this new matter for a client in the oil industry who's had trade secret theft from 11 different countries. And they're asking us, what do the privacy laws say about what they can do in terms of looking at the workstations for the people they think are stealing? And I said, gee, that's a great question, but that's not something our group handles. We've been just doing healthcare. And he looked me straight in the eye and he said, you do now. He said, there's nobody else in the firm who does what he called data stuff.
Mm.
He said, you guys are doing data stuff. It's data. You'll figure it out. So we figured it out quickly. We had to give advice in those 11 different countries, how to do the research for it. And then I was invited to join the Sedona Conference Working Group 6 shortly after that, which was the Crossborder group. And the meeting where you and I met was the third one for Group 6. The first one was just, I think, a small group of people in Arizona. And the second one I did attend was in Bermuda. And we started laying the groundwork at that point for the white paper, the framework for analysis of cross-border discovery conflicts, which is still used today.
Mm. Yeah, I mean, and it's interesting and how it all kind of ties together. And I think your point is exactly right in terms of careers, at least what I've experienced in this e-discovery, cyber and data world. They aren't lineal at all. I mean, I have a history degree. I mean, and how I ended up as a computer forensics person still shocks me, how you just end up. Doing these really interesting things. But I mean, I think it's really important, and I'm hopefully you're bringing that to your students as you're kind of expressing this to them. And so, I mean, and I definitely wanted to call out your teaching background as well. And you've been teaching for quite some time.
Yeah, I designed this course about 8 years ago when Hofstra Law School asked me to prepare one. And I live in New Jersey. Hofstra is in the middle of Long Island, so it was not geographically suitable for an 8 a.m. class, although traffic was less going in that direction at 7 o'clock or 6:30, I'll say that. But when Fordham asked me to join their faculty, I was very happy to do so, and I've been teaching the class ever since. I have to change it up every semester because of developments in the laws and technology, sometimes even mid-semester. I have to change things. We have a new case that comes down, for example. A new state comes on board with privacy law, like Virginia and Colorado just did. The Federal Trade Commission may come out with a new finding, and that's particularly critical. And then the students will often dictate the course of the semester. They have their own questions. One of the two classes I teach is for non-lawyers. It's the Masters of Compliance program at Fordham. Fordham is one of the few schools that does this. So my class is privacy and cybersecurity compliance. We have now sold out for the third semester in a row. The class is mostly chief information security officers or people in that department, chief information officers, risk and compliance. We've even had federal regulators in the class. We had somebody from the NFL recently. And if you think the NFL doesn't have privacy and cybersecurity issues, think about all the merchandising that they do. Think about all the merchandise that's sold online. And that's even before you get to the season ticket holders. So, there's a lot of information. Professional sports is really very active in the privacy and cybersecurity space.
Wow. So, I mean, hopefully, I would love to be able to take that class. So maybe I'll have to register for it. I spend quite a bit of time on the Upper West Side. So, or is it online now? Are your classes online still,
That
or have
class, no, that class, the non-lawyers class in the master's program is online. We have students from all over the United States. The law student class I teach in privacy and cybersecurity is, well, will hopefully be in person again in the spring. It's called E-Law in the Global Setting, Information Safeguards and Electronic Evidence Challenges. And we spend a amount of time on electronic evidence. And this is something that I speak to a lot when I talk to EDiscovery professionals. And EDiscovery members of EDiscovery groups. I headed EDiscovery groups in multi-district litigation pharmaceutical work when I was at Sedgwick. Judge Paul Grimm said it best in one of his opinions, where he said that spending millions of dollars to collect electronically stored information only to have it excluded because a proper foundation was not laid is a self-inflicted wound.
Mm.
Ouch. I would never want to be on the receiving end of that. But there are evidentiary elements you need to meet before you can show this stuff to a jury or a judge who is the finder of fact. And if you don't do it, you're just not going to get it in. There are ways to what we call lay a foundation for admitting physical evidence. And I do a role play with the students where I play a detective, and we have one of the students play me as an assistant district attorney to try to put a gun into evidence. And then you contrast that with a text message or a blog post or metadata. You can't, how do you establish a chain of custody when there are so many copies floating everywhere? There are ways to do it, but they're non-intuitive. Until you see what the levels of analysis are, and then it becomes fairly standard. What I try to do in my classes is give the students a way to think about these problems. What do you look at first? One way I did it in EDiscovery, and I've done this in my Bar Association lectures too, is I say to them, just because you can get every byte of data that exists around the world on a particular topic doesn't mean you should. There is a dollars and cents consequence to this. You have a litigation budget from your client. If you bust that budget, the assistant general counsel to whom you report and who sends business to your firm has to go to her direct report to get more money, and she's not going to want to do that. She's not going to want to do that. So you're going to, or worse, the firm may not get paid because you busted the budget, because you didn't think about it. So I give them 5 questions to answer before they ask for any data. What do you want? Why do you want it? Sometimes they stop at question 2 because they don't know. Where is it? How do you propose to get it here? And what will you do with it once you get it? Do you plan to use it for cross-examination? Do you plan to give it to an expert? What are you going to do with it? So they understand those levels, but to give them a way to remember it, I show them a PowerPoint slide with the Rolling Stones logo. And I said, I call this analysis the Mick Jagger rule. You can't always get what you want, but if you try, you'll get what you need. And no matter how young the students are, they generally get the reference.
Wow. Yeah, that's hopefully that doesn't change for at least a few more decades. So, I mean, you bring up an interesting point. I mean, having come from the computer forensics background, I mean, chain of custody and defensibility are key to everything that I do. And it's part of my DNA. So, do you see that there's a difference between complete defensibility or reasonable defensibility? How do you measure those two things?
I don't think there's any such thing as complete defensibility. It's like perfection in cybersecurity. It doesn't exist. It's not the standard anyway. The standard is, did you take reasonable steps to do what the regulations or the case law or the statute require you to do? And can you show it that you did? Can you document it? If you can't document it, you might as well not have done it at all. And there's a difference between defensibility of the process and meeting the requirements of, say, the federal rules of evidence in admitting electronic information. They're related, but they're not the same thing.
So what is the difference? Can you maybe
The
give us an overview
difference
of that?
is that for admissibility, you have to meet certain hoops. Is the data authentic? And you can now show that by means of certifications, comparing what you're offering with the hash values of the data from the original system you took it from. It used to be you had to call witnesses and do depositions before that, but those rules were amended a few years ago. So is it authentic? Is it subject to a hearsay exception? All right. Now, all ESI is hearsay. It's all an out-of-court statement that you're offering in court to prove the truth of whatever the statement says. So you start at that premise. Now you have to find an exception. What's an exception? The usual exception is, although there are many others, that it's a business record. All right. But there are, again, elements you have to meet to establish that it's a business record. Is this data kept in the regular course of business of the organization? And is it the regular course of the organization to keep information like this? Sounds elemental and basic, and it is, but when you start going to things like Slack or other intra-company platforms, it's not necessarily regular business documentation like an email is anymore. We had this issue with text messaging until about 5 years ago, because most companies were not using text for official company business. So you had a number of cases where judges were not admitting text messages under the business records exception. You had to find something else. Less so now, but you're still starting to you're seeing it with the internal messaging apps or the apps that are affiliated with social media platforms. If the court concludes that the use is casual and non-business, you are going to have an uphill climb getting that communication admitted. And not just admitted in court, but admitted in a way that it will be considered if it's used as an exhibit to a motion to dismiss, which is how most cases get resolved anyway. Mm. Jury trials are at an all-time low.
Yeah, and it seems to be always the case when it comes to most of the cases that I've worked with have settled. Very rarely do we end up in jury. So I mean, it sounds like, and thank you. This is very sage advice, especially I work with a lot of clients on helping them devise playbooks or EDiscovery playbooks and creating at least documentation of their process so they have something in place. It sounds like you're a great legal resource to that. But I'd like to change, kind of turn it a little bit, going back to one of the areas of practice that you were talking about in your introduction, which was around the mergers and acquisition piece. So my shameless plug for the moment is I'm going to be doing at ILTA-Con coming up in a few weeks. I'm going to be moderating a panel on mergers and private equity in the e-discovery space, which is not something that has been covered a lot. People buzz about it. But so, you do a lot of supporting, as you mentioned before, helping with the due diligence process. Could you maybe provide some insight on, again, how your e-discovery and cyber kind of ties into that practice? Because I think that's something that's overlooked a lot of times when people need to really dig into, is it a smart buy?
Yeah, I tell my students that the skills in this space are readily transferable if you're willing to think outside the box. All right. E-discovery skills are what? They are finding the data that you need to respond to particular inquiries and questions in the quickest and most cost-efficient way that you can. If you're dealing with a merger or an acquisition or an investment, there will be a data room with various documents, sometimes thousands of documents or more, that will be uploaded to that online repository for people to review. Now, if you're going to do it on a manual basis, you're going to bust the budget again, right? You're going to start doing it on an annual basis, and you're going to have some very unhappy clients. If you have a good e-discovery provider, particularly one that is using a machine learning or other AI-based tool, and you can work with your provider to tell the provider what it is you're looking for and why you're looking for it. All right. They will give you a way, just like you would when you're reviewing, files of emails or text messages. It's the same kind of stuff here. And there are companies that are already making quite a marketing effort just in the M&A space. They'll help you look for example, labor law provisions in contracts with third parties. They will help you look for export regulations provisions, obviously a critical thing, particularly in the technology space. And they'll bring those very same tools to bear in the data room. You work with your provider, you go in, you review the documents that way. If you're using a TAR sort of system, you'll get percentages of probability of a match, and then you've just reduced the universe of things you need to review. It's a little bit different than EDiscovery because you're not collecting it for production. It's already collected and it's already been produced. You may be using it to ask for more stuff. I do that a lot. I generally find that what is in the data room is nowhere near everything I need to review, and I have to keep coming back and asking for more. But it's the review of the initial documents that tell me what I need. So that can speed up the process very quickly. And I'm a little bit surprised more EDiscovery companies haven't jumped on this bandwagon because there is a crying need for it. M&A work is starting to pick up again, and I think will get even faster because you're going to have companies that were distressed as a result of the pandemic. They're going to be snatched up, but someone's going to have to do what you and I are talking about now. And it's going to have to be done fast, and it's not going to be easy to say with specificity, here's the additional stuff I need, when the target company is already trying to shut down.
So how does that compare with like a HSR second request? Is it the same vein from a workflow? Because I know those are, having worked on some of those cases in the past, it's large volumes of information. It's super fast. You have to use analytics in many cases now, which is, where a lot of people are applying those technologies. How does that fit into that?
It's very similar. It's very similar. The inquiries are different. What we're doing in the M&A and private equity space has a different goal. The goal is to advise, if we're representing the acquirer, the goal is to advise the acquirer of the risks. We're not telling the acquirer, don't go through with the deal. That's not our remit. That's going beyond what our role is. What they will generally say is, what's the risk? How can we account for it? Because they want to do the deal. Only one that I've done has a client backed away. But they want to do the deal, so they want to know, should we put an indemnification provision in the deal documents? Should we hold money in escrow? Should we put the closing off until they close the hole? Those are the questions I get asked.
Yeah, and how does that tie back into the cross-border side of things? Is that something that you're taking a risk in terms of how people are managing data, even from European companies looking to do business in the United States or APAC that have much more stricter data privacy rules? How what are you seeing in that area?
Well, you still have many of the same concerns getting the data across borders as the ones I mentioned earlier. If it's not for litigation, the risk factor goes down somewhat. Certain countries like Switzerland, for example, perceive taking data for use in a foreign judicial proceeding as an affront to sovereignty. All right. We don't have, that doesn't apply to the same extent or with the same force in a private equity investment or an acquisition. If we're representing the target, for example, we will say to the target client, here's what you need to start getting together, because having been on the other side, we know what to ask for. Mm-hmm. And here are the issues in getting the data across borders. Now, if the company is already backing up data in the U.S., you don't have really much of a problem, right? Because the data is already here. Remember those 5 questions I asked? The data is already here. If it's not here, is it being sent over for something unrelated to a judicial proceeding? Now the risk is going down a little bit. But you have to look at the local laws too. Every country has its own version of data protection laws, and you may have to go to a data protection authority and give them notice, depending on the country, and work with them before you can send the data over here. But you need to move fast because
Right.
there's money coming in the door or not, and the clients want this done quickly.
So let's wrap up with a couple what I call Yoda moments. So if give us in terms of if you have some tips of there. So we're gonna do as I call a thin Yoda versus a thick Yoda. So what tips would you offer to acquiring companies in terms of things they need to be aware of from a cyber perspective?
Well, cyber, you mean security or do you mean privacy or both?
Both.
All right, yeah, and that's a good point. The Europeans use the term data protection, which comprises both. The Americans still keep it in silos, which frankly just gets everybody confused.
Mm.
But from that perspective, um, find your policies and procedures and upload them to the data room quickly. Make sure they're current. If you haven't done a risk assessment, security risk assessment in the last 12 months, do it now because the acquirer is probably going to ask for it. If you have certifications for your security, either ISO 27001, SOC 2, or UK Cyber Essentials or CIS controls, make sure it's current because that would be very helpful as well. So I'd make sure that you have that in place. Get all your third-party contracts in one place so that the acquirer's counsel can review the ones that are necessary. Just in general, start getting yourself ready for the kinds of questions that you'll be asked. Also, take a look at your cyber and privacy liability insurance and your technology errors and omissions, and see how transferable that is, if it may be, it may not be, and see what it may say about coverage for data incidents that may occur during the review process. If it's an exclusion, you need to tell your senior management about that and your IT folks, so you make even more sure than you would otherwise that your information is protected. Now, if you're uploading to a data room, this I shouldn't even need to say. Make sure that you're uploading it in encrypted format, right? Make sure that the data room platform you're using is appropriately encrypted and protected. And for goodness sakes, don't send the password over email. I got one last week from a client's IT person, and I thought, man, my grandmother used to say sometimes the shoemaker's children don't have shoes, and this was just a good example of that. Find another way.
Right. Well, Ken, I can't thank you enough for your time, and one day I'll have to dig in a little bit more on the cyber and the insurance side of things because that's actually an interesting topic. But I know that you have another meeting coming up real soon, and I don't want to take too much more of your time. But maybe if you could let our listeners know how they can get a hold of you and how they can find you, that would be great.
Sure. My firm is Barton, Barton LLP. The website is bartonesq, one word, .com. I'm also on LinkedIn, and I'd be happy to talk to any of you at any time. I return my texts and emails and calls very quickly. It's something I was trained in a long time ago. If you want to if you want to do it the old school way and use the phone, happy to talk to you on the telephone as well. My phone number is on the firm website. Be glad to talk to you at any time.
Well, we'll definitely we'll add those to the links to the liner note for our for as part of the podcast and people by all means I think this is great. Ken, you've always been very accessible for me, so I really appreciate that, and it is very true. You do get back to people very quickly. So everyone, thank you again, and thank you, Ken, for joining us on this episode of Out of Curiosity. For those listening, make sure that you're subscribing and liking on the appropriate platform. We're on Amazon now, iTunes, and YouTube, and a couple other platforms, Spotify. So please like and subscribe. So thank you, Ken. I appreciate your time, and thank you, everyone, for joining us for this episode of Out of Curiosity.
Thank you, Jason. Always a pleasure. Look forward to talking to you again soon.
Thank you so much. Have a great day, everyone.